We back. Negotiation by transfer. 159.1. A bill is negotiated when it is transferred from one person to another in such a manner as to constitute the transferee the holder of the bill. By delivery. 2. A bill payable to bearer is negotiated by delivery. By endorsement. 3. A bill payable to order is negotiated by the endorsement of the holder. Without endorsement. 61. Where the holder of a bill payable to his order transfers it for value without endorsing it, the transfer gives the transferee such title as the transferor had in the bill, and the transferee, in addition, acquires the right to have the endorsement of the transferor. Representative capacity. 2. Where any person is under obligation to endorse a bill in a representative capacity, he may endorse the bill in such term as to negative personal liability. Endorsing. 61.1. An endorsement, in order to operate as a negotiation, must be A. Written on the bill itself and be signed by the endorser, and B. An endorsement of the entire bill. Allonge. 2. An endorsement written on a allonge or on a copy of a bill issued or negotiated in a country where copies are recognized is deemed to be written on the bill itself. Partial endorsement. 3. A partial endorsement, that is to say, an endorsement that purports to transfer to the endorsee a part only of the amount payable, or that purports to transfer the bill or to two or more endorsees severally, does not operate as a negotiation of the bill. Signature sufficient. 62.1. The simple signature of the endorser on a bill without additional words is a sufficient endorsement. 2 or more payees. 2. Where a bill is payable to the order of 2 or more payees or endorsees who are not partners, all must endorse unless the one endorsing has authority to endorse for the others. Misspelling payee's name. 63. Where in a bill payable to order, the payee or endorsee is wrongly designated or his name is misspelled, he may endorse the bill as therein described, adding his proper signature, or he may endorse by his proper signature. Presumption as to order of endorsement. 64. Where there are 2 or more endorsements on a bill, each endorsement is deemed to have been made in the order in which it appears on the bill, until the contrary is proved. Disregarding condition. 65. Where a bill purports to be endorsed conditionally, the condition may be regarded by the payer, and payment to the endorsee is valid, whether the condition has been fulfilled or not. Endorsement 66.1. An endorsement may be made in blank or special in blank. 2. An endorsement in blank specifies no endorsee, and a bill so endorsed becomes payable to bearer. Special 3. A special endorsement specifies the person to whom or to whose order the bill is to be payable. Application of Act 4. The provisions of this Act relating to a payee apply, with such modifications as the circumstances require, to an endorsee under a special endorsement. Conversion of blank endorsement 5. Where a bill has been endorsed in blank, any holder may convert the blank endorsement into a special endorsement by writing above the endorser's signature a direction to pay the bill to or to the order of himself or some other person. Restrictive endorsement 67.1. An endorsement may contain terms making it restrictive. Edom. 2. An endorsement is restrictive that prohibits the further negotiation of the bill, or that expressions that it is a mere authority to deal with the bill as thereby directed, and not a transfer of the ownership thereof, as, for example, if a bill is endorsed, pay only, or pay for the amount of, or pay or order for collection. Rights of endorsee 3. A restrictive endorsement gives the endorsee the right to receive payment of the bill and to sue any party thereto that his endorser could have sued, but gives him no power to transfer his rights as endorsee unless it expressly authorizes him to do so, if further transfer is authorized. 4. Where a restrictive endorsement authorized further transfer, all subsequent endorsees take the bill with the same rights and subject to the same liabilities as the first endorsee under the restrictive endorsement. When negotiability ceases. 68. Where a bill is negotiable in its origin, it continues to be negotiable until it has been A. restrictively endorsed, or B. discharged by payment or otherwise. Overdue bill 69.1. Where an overdue bill is negotiated, it can be negotiated only subject to any defect of title affecting it at its maturity, and henceforward no person who takes it can acquire or give a better title than the person from whom he took it had. When demand bill overdue. 2. A bill payable on demand is deemed to be overdue within the meaning and for the purpose of this section when it appears on the face of it to have been in circulation for an unreasonable length of time. 3. What is an unreasonable length of time for the purpose of subsection 2 is a question of fact. Presumption 70. Except where an endorsement bears date after the maturity of the bill. Every negotiation is, in the absence of evidence to the contrary, deemed to have been effected before the bill was overdue. Taking bill with notice of dishonor. 71. Where a bill that is not overdue has been dishonored, any person who takes it with notice of dishonor takes it subject to any defect of title attaching thereto at the time of dishonor, but nothing in this section affects the right of a holder in due course. Reissue a bill. 72. Where a bill is negotiated back to the drawer, to a prior endorser, or to the acceptor, that party may, subject to this act, reissue and further negotiate the bill, but he is not entitled to enforce the payment of the bill against any intervening party to whom he was previously liable. Rights and powers of holder. Rights and power of holder. 73. The rights and power of holder of a bill are as follows. A. He may sue on the bill in his own name. B. Where he is a holder in due course, he holds the bill free from any defect of title of prior parties, as well as from mere personal defenses available to prior parties among themselves, and may enforce payment against all parties liable on the bill. C. Where his title is defective, if he negotiates the bill to a holder in due course, that holder obtains a good and complete title to the bill. And D. Where his title is defective, if he obtains payment of the bill, the person who pays him in due course gets a valid discharge for the bill. Presentment for acceptance. When presentment for acceptance necessary. 74. 1. Where a bill is payable at sight and or after sight, presentment for acceptance is necessary in order to fix the maturity of the instrument. Express stipulation. 2. Where a bill expressly stipulates that it shall be presented for acceptance, or where a bill is drawn payable elsewhere than at the residence or place of business of the drawee, it must be presented for acceptance before it can be presented for payment. Other cases. 3. In no other case is presentment for acceptance necessary in order to render liability any party to the bill. Presentment excused. 75. Where the holder of a bill drawn payable elsewhere than at the place of business or residence of the drawee has not time, with the exercise of reasonable diligence, to present the bill for acceptance before presenting it for payment on the day that it falls due, the delay caused by presenting the bill for acceptance before presenting it for payment is excused and does not discharge the drawer and endorsers. Site bill. 76. 1. Subject to this act, when a bill payable at sight or after sight is negotiated, the holder must either present it for acceptance or negotiate it within a reasonable time. if not presented. 2, if the holder does not comply with the requirement of subsection 1, the drawer and all endorsers prior to that holder are discharged. Reasonable time. 3. In determining what is a reasonable time within the meaning of this section, regard shall be had to the nature of the bill, the usage of trade with respect to similar bills, and the facts of the particular case. Rules for presenting for acceptance. 77. A bill is duly presented for acceptance, that is, presented in accordance with the following rules. A. The presentment must be made by or on behalf of the holder to the drawee or to a person authorized to accept or refuse acceptance on his behalf at a reasonable hour on a business day and before the bill is overdue. B. Where a bill is addressed to 2 or more drawees who are not partners, presentment must be made to all of them unless one has authority to accept for all, in which case presentment may be made to him only. C. Where the drawee is dead, presentment may be made to his personal representative. And D. Where authorized by agreement or usage, a presentment through the post office is sufficient. Excuses. 78. 1. Presentment in accordance with the rules set out in section 77 is excused, and a bill may be treated as dishonored by non-acceptance where 1. The drawee is dead or is a fictitious person or a person not having capacity to contract the bill. B. After the exercise of reasonable diligence, the presentment cannot be effected. Or C. Although the presentment has been irregular, acceptance has been refused on some other ground. No excuse. 2. The fact that the holder has reason to believe that the bill on presentment will be dishonored does not excuse presentment. Time for acceptance. 79. 1. The drawee may accept a bill on the day of its due presentment to him for acceptance or at any time within 2 days thereafter. Dishonor. 2. When a bill is duly presented for acceptance and is not accepted within the time mentioned in subsection 1, the person presenting it must treat it as dishonor by non-acceptance. Loss of right. 3. If the person does not treat the bill as dishonored, the holder loses his right of recourse against the drawer and endorsers. Date of acceptance. 4. In the case of a bill payable at sight or after sight, the acceptor may date his acceptance thereon as of any of the days mentioned in subsection 1, but not later than the day of his actual acceptance of the bill. Refusing acceptance. 5. If the acceptance is not dated as described in subsection 4, the holder may refuse to take the acceptance and may treat the bill as dishonored by non-acceptance. Dishonor by non-acceptance. 80. A bill is dishonored by non-acceptance when A. It is duly presented for acceptance and such an acceptance as it prescribed by this act is refused or cannot be obtained, or B. Presentment for acceptance is excused and the bill is not accepted. Recourse 81. Subject to this act, when a bill is dishonored by non-acceptance, an immediate right of recourse against the drawer and endorsers accrues to the holder, and no presentment for payment is necessary. Qualified acceptance 82.1. The holder of a bill may refuse to take a qualified acceptance, and if he does not obtain an unqualified acceptance, may treat the bill as dishonored for non-acceptance. Presumption of assent. 2. When the drawer or endorser of a bill receives notice of a qualified acceptance and does not within a reasonable time express his dissent to the holder, he shall be deemed to have assented thereto. Qualified acceptance without authority. 83.1. Where a qualified acceptance is taken and the drawer or endorser has not expressly or impliedly authorized the holder to take a qualified acceptance or does not subsequently assent thereto, the drawer or endorser is discharged from his liability on the bill. Partial acceptance. 2. This section does not apply to a partial acceptance of which due notice has been given. Presentment for payment. Necessity for presentment 84.1. Subject to this act, a bill must be duly presented for payment. If not presented. 2. If a bill is not duly presented for payment, the drawer or endorsers are discharged. Manner of presentment. 3. Where the holder of a bill presents it for payment, he shall exhibit the bill to the person from whom he demands payment. I'm going to read that one over. 3. Where the holder of a bill presents it for payment, he shall exhibit the bill to the person from whom he demands payment. Time for presentment 85.1. A bill is duly presented for payment, that is, presented when the bill is A. Not payable on demand on the day it falls due, or B. Payable on demand within a reasonable time after its issue, in order to render the drawer liable, and within a reasonable time after its endorsement in order to render the endorser liable. Reasonable time. 2. In determining what is a reasonable time within the meaning of this section, regard shall be had to the nature of the bill, the usage of trade with respect to similar bills, and the facts of the particular case. By and to whom. 86.1. Presentment of a bill must be made by the holder or by a person authorized to receive payment on his behalf at the proper place as defined in section 87, and either to the person designated by the bill as payer or to his representative or a person authorized to pay or to refuse payment on his behalf, if with the exercise of reasonable diligence such person can there be found. 2 acceptors. 2. When a bill is drawn on or accepted by 2 or more persons who are not partners and no place of payment is specified, presentment must be made to all of them. personal representation. 3. When the drawee or acceptor of a bill is dead and no place of payment is specified, presentment of the bill must be made to a personal representative, for there is one, and with the exercise of reasonable diligence he can be found. Proper place for presentment. 87. A bill is presented at the proper place. A. Where a place of payment is specified in the bill or acceptance and the bill is there presented. B. Where no place of payment is specified but the address of the drawee or acceptor is given in the bill and the bill is there presented. C. Where no place of payment is specified and no address given, and the bill is presented to the drawee's or acceptor's place of business, if known, or if not, at his ordinary residence, if known, or D. In any other case, if presented to the drawee or acceptor, wherever he can be found, or if presented at his last known place of business or residence. Sufficient presentment. 88. Where a bill is presented at the proper place as defined in section 87 and after the exercise of reasonable diligence, no person authorized to pay or refuse payment can be found. No further presentment to the drawee or acceptor is required. Presentment at post office. 89. 1. Where the place of payment specified in the bill or acceptance is any city, town, or village, and no place therein is specified, and the bill is presented at the drawee's or acceptor's known place of business or known ordinary residence therein, and if there is no such place of business or residence, the bill is presented at the post office or principal post office in such city, town, or village. Such presentment is sufficient. Through post office. 2. Where authorized by agreement or usage, a presentment through the post office is sufficient. Delay in presentment. 91. Delay in making presentment of a bill for payment is excused where the delay is caused by circumstances beyond the control of the holder or not imputable to his default, misconduct, or negligence. Diligence. 2. Where the cause of delay ceases to operate, presentment must be made with reasonable diligence. When presentment is dispensed with. 91. 1. Presentment of a bill for payment is dispensed with. A. Where after the exercise of reasonable diligence, presentment as required by this act cannot be effected. B. Where the drawee is a fictitious person. C. With respect to the drawer, where the drawee or acceptor is not bound, as between himself and the drawer, to accept or pay the bill, and the drawer has no reason to believe that the bill would be paid if presented. Or D. With respect to an endorser, where the bill was accepted or made for the accommodation of that endorser, and he has no reason to expect that the bill would be paid for if presented. E. by waiver of presentment express or implied, not dispensed with. 2. The fact that the holder has reason to believe that the bill will, on presentment, be dishonored does not dispense with the necessity for presentment. When no place specified. 92.1. When no place of payment is specified in a bill or acceptance, presentment for payment is not necessary in order to render the acceptor liable. If place specified. 2. When a place of payment is specified in a bill or acceptance, the acceptor, in the absence of an express stipulation to that effect, is not discharged by the omission to present the bill for payment on the day that it matures. But if any suit or action is instituted thereon before presentation, the causes thereof shall be in the discretion of the court. Delivery on payment. 3. When a bill is paid, the holder shall forthwith deliver it to the party paying it. Time for presentment. 93.1. Where the address of the acceptor for honor on a bill is in the same place where the bill is protested for non-payment, the bill must be presented to him no later than the day following its maturity. Parties in different places. 2. Where the address of the acceptor for honor is in a place other than the place where a bill is protested for non-payment, the bill must be forwarded not later than the day following its maturity for presentment to him. Excuses for delay. 3. Delay in presentment or non-presentment is excused by any circumstance that would, in case of acceptance by a drawee, excuse delay in presentment for payment or non-presentment for payment. Dishonor by non-payment. 94.1. A bill is dishonored by non-payment when A. It is duly presented for payment and payment is refused or cannot be obtained, or B. Presentment is excused and the bill is overdue and unpaid. Recourse. 2. Subject to this act, when a bill is dishonored by non-payment, an immediate right of recourse against the drawer, acceptor, and endorsers accrues to the holder. Notice of dishonor. When we come back, we're going to get to notice of dishonor.